That brings me to point number 3, which I entitled, What the Heck? A criminal conviction can also prevent you from getting justice on a misconduct claim against the police. Let's use the example that I just said before. A person is badly beaten, they have serious injuries, but they're facing one count of Penal Code 69, felony assault on an officer, and another count of PC 148, misdemeanor resisting arrest. Now, the felony assault carries possible penalties of up to 3 years in jail, maybe more. But the DA says, how about we just resolve it for the misdemeanor and we'll let you out of jail right now? Now, is that a good deal? Maybe. If the person did commit an assault, if the person is at real risk of a felony conviction, then sure, that might be a smart thing to do to reduce risk and get the case over with. But understand this, a criminal plea can prevent you from bringing an excessive force case later. It can preclude it as a matter of law. You could plead to a misdemeanor criminal offense for resisting, for example, and that can mean that you cannot sue the police later and say that they used excessive or unnecessary force on you. That case could just get thrown out of court because essentially you've already admitted that you were resisting, which would entitle them to use force. What the heck, you say? Exactly, I say. And forgive the dad joke, but the Supreme Court case establishing this rule is called Heck v. Humphrey. And the rule that it established is called the Heck Doctrine. The rule is a plaintiff is prevented from pursuing a civil rights claim that, if successful, would necessarily imply the invalidity of a conviction or a sentence. Not all pleas result in a Heck bar. Necessarily is an important word in that holding, and plea agreements and their factual bases can be crafted so that they don't undermine a later civil rights lawsuit. But this is tricky. Pleas end up falling directly into the Heck trap, and many civil rights lawsuits end up Heck barred. Call me cynical, but I suspect that when the police hurt somebody, DAs and city attorneys are motivated to get pleas that prevent their cops from being sued later, and they set out to do exactly that. So beware of the Heck bar is another message that I want you to take away.